In July of 1978, the United States Supreme Court issued its decision in Federal Communications Commission versus Pacifica Foundation. The vote was 5-4. The majority held that the FCC had been within its constitutional authority to sanction Pacifica Radio for broadcasting at 2 o'clock in the afternoon a 12-minute recorded comedy routine by George Carlin. Carlin was at home when the decision came down. The people who were with him that day, people who knew him well, who understood his relationship with the material that had become the center of a federal legal case, expected a specific kind of reaction. They expected anger or bitterness, or the particular frustration of an artist whose work has been used as the test case for a legal principle he disagrees with and has now lost. What they got was something else entirely. Carlin's response to the Supreme Court ruling against him was not what anyone in the room anticipated. And what he said in the days and weeks that followed, in interviews, in private conversations, in the specific way he began to incorporate the ruling into his understanding of what had happened, was not the response of a man who felt defeated. To understand why requires going back to the beginning of the case. Not to 1978, when the ruling came down, but to 1973, when the routine was first broadcast, and to 1972, when the routine was first performed, and to the question of what Carlin understood about the relationship between the law and the material from the beginning. Because the thing that distinguished Carlin's reaction to the ruling from what most people expected is this: he had never believed that the legal case was about what the legal system thought it was about. The court believed it was ruling on a matter of broadcast regulation, on the FCC's authority to restrict indecent content during hours when children might be listening, on the balance between free speech and the government's interest in protecting audiences from content they had not chosen. Carlin believed something different. He believed the case was about something the law was not equipped to rule on, and the ruling, when it came, proved him right. Carlin's response to the ruling, in the days immediately after it was issued, was not what the press expected, and was not what the people who had followed the case expected. The ruling had gone against Pacifica, against, in effect, the principle that the material could be broadcast without restriction. The 5-4 vote was narrow enough to signal that the legal question was genuinely contested, but the outcome was clear. The FCC had the authority it had asserted, and the broadcast of the routine at 2 in the afternoon had been regulable.
Carlin, asked to respond, was measured. He was not theatrical about it. He did not perform outrage for the cameras. He did not make the kind of statement that a comedian who wanted to get maximum value out of a Supreme Court ruling being named after their material would make. What he said was, in essence, that the court had ruled on the one question it could rule on, the FCC's authority, and had not ruled on, and could not rule on, the more interesting questions: whether the prohibition was sensible, whether the specific words at issue were actually harmful, whether the distinction between a word and its referent had any logical basis, whether the protection of children from certain words in certain contexts served any purpose that could be defended in the light of a serious examination. These questions, Carlin pointed out, the court had declined to engage, and that was, from his perspective, the most significant thing about the ruling. Not that he had lost, not that the FCC had won, but that the court had ruled on the regulatory question and left the underlying question, the question the material had actually been asking, completely untouched. This was, Carlin understood, exactly how it was going to be. The law was not designed to engage with the questions that comedy raised. The law was designed to regulate behavior, to define what was and wasn't permitted, to establish the lines and enforce them. The questions behind the lines, why these lines, why here, what purpose these specific prohibitions served, were not legal questions. They were cultural and philosophical questions, and they were the questions the material had been asking. The material had been asking these questions since 1972. It would continue to ask them after 1978. The ruling had no effect on the questions. And what Carlin understood, and what his measured response to the ruling reflected, was this: the court had ruled on the broadcast. It had not ruled on the thought. The broadcast could be restricted. The thought was already out. The routine had been out in the world since 1973, on the album, in performances, in the cultural conversation that had grown up around it in the 5 years between the broadcast and the ruling. Millions of people had heard it, had thought about it, had found themselves asking the questions it raised, about language, about prohibition, about the specific arbitrariness of the rules governing what could be said, where. No ruling could unask those questions. And Carlin knew this, which is why, when the ruling came down, he was not upset in the way that people expected. The routine at the center of the case, a recording of a performance called "Filthy Words" from Carlin's 1973 album, Class Clown, was not the same thing as the earlier routine that became known as 7 Words You Can Never Say on Television. This distinction matters. The routine broadcast by Pacifica Radio's WBAI station in New York on October 30th, 1973, was a 12-minute exploration of the specific words that American broadcast standards prohibited, delivered in Carlin's characteristic style, precise, analytical, comic, and genuinely interested in the question of why these particular words, in this particular context, were prohibited, while their synonyms and their reference were not. The routine was not an attempt to shock. Anyone who listened to it with attention understood that it was, at its core, a piece of comedy philosophy, an examination of the arbitrary nature of linguistic prohibition, of the specific way that some words become unsayable, while the things they refer to remain freely discussable. It was the kind of comedy that requires the audience to think about what they are hearing, rather than simply react to it. But Pacifica had broadcasted at 2 p.m, without prior warning, in a time slot that the FCC considered part of the period when children were likely to be in the radio audience. A man who heard it while driving with his son complained to the FCC. The FCC issued a notice of liability to Pacifica. Pacifica challenged the FCC's authority to issue that notice. The case worked its way through the federal courts for 5 years. By the time it reached the Supreme Court, it had acquired a significance that exceeded the specific incident that had generated it. The case had become a test of the FCC's authority to regulate broadcast content more broadly, of the degree to which the government could restrict the content of radio and television in the name of protecting audiences who had not consented to the specific content they received. Carlin was not a party to the case. The FCC had sanctioned Pacifica, not Carlin. He had no legal standing in the proceedings, and no ability to direct the argument being made on the side that, in effect, was defending his material. He was watching a legal case proceed about a piece of his work in which he was technically a bystander. But he had opinions about it. He had been following the case for 5 years. And what he had concluded, by the time the Supreme Court took it up, was the thing that informed his response when the ruling came down. He had concluded that the court was going to rule on the wrong question, and that this meant that whatever the court decided, it was going to have less effect than either side in the case believed. The court was ruling on the FCC's authority to restrict broadcast content. It could not, rule on the material itself, on what the routine was, on what it meant, on what it had already become in the culture in the 5 years since the broadcast. And what it had already become was the thing the ruling could not touch. No court can unsay something that has already been said. In the years after the ruling, George Carlin spoke about it with a consistency that revealed how he had thought about it from the beginning. He did not describe it as a defeat. He did not describe it as a victory either. He was not interested in the frame of winning and losing as it applied to a legal case about his material. What he described, when he described it at all, was the specific quality of the ruling as an inadvertent demonstration of exactly what the material had been about. The routine had been about language, about the specific words that were prohibited in broadcast contexts, about the arbitrariness of the prohibition, the fact that the words themselves were not harmful, that their reference could be discussed freely, that the prohibition was based on convention rather than on any principle that could be defended under examination. The FCC's sanctioning of Pacifica, the 5-year legal case, and the Supreme Court ruling had demonstrated in the most public and official way possible that the prohibition was exactly as arbitrary as the routine had suggested. The court had ruled that the FCC could restrict the broadcast of certain words, but the court had not provided, had not even attempted to provide, a principled account of why these specific words were prohibitable, while their synonyms and referents were not. The ruling had been, in Carlin's analysis, exactly what he had predicted: the government defending a rule without examining it. The prohibition preserved because preserving it was what the system was designed to do, not because anyone had demonstrated that the preservation served a purpose. Carlin found this, if not satisfying, then at least confirming. The case had ended at the Supreme Court with a 5-4 ruling that left the underlying question completely unresolved, which was exactly what he had expected. And the material, 7 words you can never say on television, the routine that had started the whole thing, went on. It remained part of his performances. It remained on the album. It remained in the culture as one of the clearest examples in American comedy of the specific kind of comedy that uses humor to examine a genuine absurdity in the rules that govern what can and cannot be said. The FCC ruling had made Carlin's name more widely known than it had been before the case. The Supreme Court ruling had made the material more famous than it would have been if the broadcast had simply been ignored. The government's attempt to prohibit the broadcast of the routine had accomplished, as such attempts often do, the opposite of what it intended. The words had been said. They were in the world. The questions they raised were in the world. The court could rule on the broadcast. It could not rule on the thought. Decades later, the material is still in circulation. The questions it asks are still available to anyone who encounters the routine for the first time, still as fresh, still as genuinely interesting as they were when the routine was first performed. The FCC sanctioned Pacifica. The Supreme Court upheld the sanction. But nobody unsaid what had been said. That is the thing about the true thought, said clearly at the right moment. The law can regulate the broadcast. It cannot regulate the thought. Carlin knew this on the day the ruling came down, and that is why,
When everyone around him expected anger or bitterness or the frustration of someone who had lost at the highest court in the country, what they got instead was something quieter, something closer to confirmation.